pending the determination by this court of the applicant's review under case number 2026/119192, the first and second respondents are interdicted from proceeding with a public impeachment hearing in terms of Rule 129 M of the National Assembly Rules.
I think people are innocent until proven guilty, so I do think that we should have due process.
I think it's a great process. I don't think anything will come out of it. I think he will duck and dive. Same scenario as with Zuma.
I don't see President as a dishonest man.
You cannot preach positivity and anti-corruption, and now you're doing something different. So I'm not too sure anymore about our president.
The pause button has been pressed. What does it all mean? It's topical, and it starts right now. A very good evening to you, South Africa, and those watching around the world. My name is Blaine Herman, and this is It's Topical. Tonight, a consequential courtroom ruling. The public impeachment process against President Cyril Ramaphosa has been put on hold. The Western Cape High Court, by a majority decision, has temporarily stopped Parliament's Section 89 impeachment proceedings while the President's challenge to the independent Phala Phala panel report is heard. 3 judges, 3 judgments, 1 outcome. The ruling itself lasted, barely 2.5 minutes? The political and consequential impact, well, potentially far longer. President Cyril Ramaphosa says he respects the independence of the judiciary, the separation of powers, and remains committed to accountability. In the latest developments, the African Transformation Movement has instructed its legal team to urgently approach the Constitutional Court to seek clarity on the implementation and effect of its order relating to the Section 89 impeachment process. Now, the party says it is concerned that the Western Cape High Court judgment has created significant constitutional uncertainty. Does this all boil down to constitutional sequencing? What is the practical effect of the order? We will discuss with the better minds. It leads us to the question of the week. And we're asking you, the Western Cape High Court has paused the public impeachment hearings against President Cyril Ramaphosa pending his review application of the independent panel report. What do you make of this ruling? Let us know your thoughts. Engage with us on Facebook, SABC. We're also opening up the lines. Tonight, we would love to hear from you live on air. 011-714-0677-7879. That number on your screen, 011-714-0677-7879. Get calling. I'll talk to you live on air. Perspective coming up. So, I want to give you some context. Have a look at this slide. 3 judgments. The matter was argued before the Western Cape High Court for 2 days, right? These were the 3 judges right here. The first judgment concluded that the president did not make out a case for an interim interdict and proposed the application be dismissed. The second judgment concluded that the president did make out a case for an interim interdict, meaning what? Well, it proposed an interdict of limited duration. The third judgment concurred with the second judgment, making it the majority judgment, right? So, what does this all mean in terms of process? That means pending the determination of the president's review of the independent panel report, the public impeachment hearings are interdicted, right? That's that part. So, that review is scheduled to be heard in the first week of September. So tease up tonight's discussion with regards to the panel report review. We will take it now to the better minds and discuss this further. I want to introduce my guest. Dr. Shadi Makhano is a senior lecturer at Wits University's Law School. Thank you so much indeed for your time, Doc. Joining us online is Lawson Naidoo, is the Executive Director of the Council for the Advancement of the South African Constitution, as well as Professor Spamandla Zondi from the University of Johannesburg's Department of Politics and International Relations. They will pop up on your screen that you see them now. Thank you so much indeed for joining us. It's a discussion I think we need to kind of flesh out. There's been discussion on this, but I think there's some grey areas with regards to the actual effect of the order. Doc, maybe I'll start with you with regards to the ATM now approaching the Constitutional Court. They're saying they're seeking clarity on Section 89 impeachment process. They feel it's necessary for the Constitutional Court to clarify whether the implementation of one of its own orders may be suspended by a lower court. Is there validity in that argument?
There could be, and I think the reason why I'm saying there could be is because of the way the judgment came from the High Court, right? So remember, we had 3 judgments. So if we had all 3 unanimously agreeing, I think it would have been easier. So if you look at the majority, it prioritized the rule of law, and then it basically said that Parliament should not proceed based on a report whose foundation is being legally questioned, right? And then if you look at the dissenting judgment, it prioritized Parliament's constitutional power to hold the executive accountable. And I think that's where the challenge is coming in. That's why ATM was able to approach the Constitutional Court to say there's an issue when it comes to a hierarchy of courts. So whether there's an issue when it comes to the hierarchy of courts, I'm not quite sure in that sense, because remember, the Constitutional Court only triggered the impeachment process through that decision. So the High Court is basically saying, let's put a pause on the work of Parliament to review the foundation of that impeachment process. Right. So the Constitutional Court, in that sense, would have to decide whether there was an encroachment in its constitutional powers in that sense. But I don't know, I don't think the first step in this sense would have to be ATM basically convincing the Constitutional Court that it should be the court of first and final instance in this sense. Because remember, it's a High Court decision. The next step is to go through the Supreme Court of Appeal. So if it's jumping that step, it needs to also convince the Constitutional Court that we don't want to go through the SCA first. We want you to look at this matter and just close it.
Lawson Naidoo, valid clarification from the ATM?
No, I don't think so, Blaine. Whilst there was a split decision in the court, all 3 judges agreed that the court, in fact, had jurisdiction to hear the matter, that despite the ruling of the Constitutional Court, there was nothing to preclude the Western Cape High Court from considering the President's application for an interim interdict. So I think there's very little scope that the Constitutional Court will intervene in this matter. I think it's also important, Blaine, in the broader context of the 3 judgments, all 3 judgments agreed on the legal test to be applied for the granting of an interim interdict. Where they differed was in their assessment of that legal test as it applied to the specific facts of this case, with the dissenting judge finding that the president would not suffer irreparable harm, and the other 2 judges doing that. So there's no real question of a legal vagueness or a legal disagreement. It was a disagreement on the basis of how you apply those legal tests to the facts of the case. So I think there's very little, if not no scope for an appeal, especially as an appeal against an interim interdict has to be done in very, very extraordinary circumstances. It's not the normal practice.
The legal test as it relates to the balance of convenience, weighing the potential prejudice or harm to the applicant against the prejudice or harm to the respondent. Professor, I wonder how this plays, given all the legalities around it. How does this play out, not only in the court of public opinion, but also in the political circles?
Oh yes, it is a matter that is being watched very strongly by all political actors and civil sector actors in society, because it has huge implications for how politically we understand our constitutional order, the accountability of the president, and the role of the judiciary in facilitating an orderly society and in responding to the popular aspirations on the ground. But definitely, in relation to the president and the governing party, it provides a political reprieve so that the president does not have to face these issues immediately. But as the legality, procedural, legal matters are being argued, they can then be developing a political strategy about how they will manage the impeachment process, which is a process which is partly legal, partly political.
Yeah.
And the legal goons the president has hired will handle the legal elements. He now needs to think about the political elements, because there will be political elements that has to be argued in this particular case. And unfortunately, the process is damaging. It will be politically damaging. Whatever you plan to do without it, it should now be about how do you manage the political the damages that come out of this once the legal and procedural processes are over. So this provides a space to think through those at the moment. But generally for the public, these things can be easily misinterpreted either as victory for the president or a president trying to avoid scrutiny. Those questions will continue to bubble up in our public discourse.
I want to, just flesh out this a little bit so the public has a good understanding in terms of when you think about an apex court and what sort of precedence does this set when it seems, or when a lower court is seen to have suspended the implementation of an apex court order?
I don't think the lower court basically stopped or it encroached on the order of an apex court. I think that's where the challenge is coming from. So the Constitutional Court made an order on the rules of Parliament, right, which triggered the impeachment process. So when the High Court basically said the work of Parliament should be paused, it used a test that also comes from a Concord decision. So if you look at National Treasury versus Outer, that's the test, that those 4 requirements, that's where they come from, right? So the same court or the same court decision basically said courts should be slow to interfere or interrupt in to interrupt in the exercise of public power when it comes to another branch of government. It doesn't say that it's not allowed or courts are not allowed to stop or interrupt if it's legally justifiable. So what basically happened in this instance is that the president or his legal representatives were able to prove that this is one of those exceptional circumstances that come from outer to put a pause on the work of Parliament. Also, it's an interim interdict, so it's not final. It doesn't stop Parliament from doing its work. And I think also, if you read that decision, I think the court was very wary of not interrupting the whole work of Parliament, because it said no public hearings.
Yes.
So what it basically also means is that Parliament can continue in the background with other administrative work, but it cannot continue with the public hearings. And then if you remember, before the interdict decision, Parliament was working on their terms of reference and also deciding on a list of evidence leaders, right? So that's part of the admin that they would have to work on before they start with the public hearings. So I think those are the things that Parliament can continue with. What they cannot do until that report has been reviewed is do the public hearings. So the court didn't necessarily also just take all the power of Parliament. It just put a pause on some of it and said you can continue with some of your admin work, but don't do the public hearings yet, because the foundation of your impeachment process is under review.
Lawson, is that how you understand it in terms of this interim interdict? It simply stops the public hearing aspect of it, but everything else continues. Is that your understanding?
Indeed it is, because I think it's very clear from the order of the High Court that that's exactly what the interdict is aimed at, and it uses the phrase public hearings. Because when it comes to the preparatory work of the committee, as the doctor has just said, the finalization of the evidence leaders and the terms of reference of the impeachment committee itself, the president would suffer no irreparable harm from the committee doing that. And so the aim of the interdict is to protect that limited protection for the president against the irreparable harm that he would suffer from going through a public inquiry process. So I think the judgment is very clear. in that regard. And, I think the argument that the ATM are making now in going to the Constitutional Court and saying they're seeking clarity on the effect of the judgment, I think the effect of the judgment is very, very clear.
Yeah. Prof, I wonder how much of a breather this is politically for the president. It's an interim order. The review process kicks off in the first week of September. What's your assessment in terms of how much space he has?
Yes, in terms of the political process in Parliament, there is a reprieve. The public hearings won't take place for some time now, so which means the president is not going to face public scrutiny in a very public impeachment process with all sorts of probing questions and sniping comments from political parties and playing the game. Definitely not in August. Definitely probably not in September. So that is a reprieve from that formal political process. What it doesn't get a reprieve from is public scrutiny outside the public process, because the political parties are picking this up and putting it in every direction. And I suspect that this is going to continue to be an engagement within Parliament, engagement among political parties, and then in the public sphere, including in the media, that will try to argue either that the president is following a legal process and a constitutional process and stuff like that. It's within his right to do that and all that. That's a proper argument politically. But there are also others who are arguing that the president is trying to avoid public scrutiny. The president who came to power as an accountable figure, as somebody who is open and that is less than transparent, is using the courts like the former president in order to avoid political scrutiny. Those arguments will continue. And then the general public, right now in South Africa, as it is on the continent, according to recent Afrobarometer, is the public confidence in public institutions is at its lowest, and people are the support for democracy generally is at its lowest. The support for this public institution is at its lowest, and I guess in that condition, and under those conditions, this matter will simply add to public anguish and public concern, and perhaps might also continue to drive the wedge between those who are in power and those who are the citizens of society and are concerned about the life that they have to live. Unfortunately, under these conditions, also with the unemployment, the socioeconomic difficult matters of this nature become politically charged, especially in the year of elections. And so the president is not fully off the hook because the campaign also for local government election has started, and this issue is an easy issue to use to campaign against the governing party. And the other parties that are in the GNU, especially the DA, has a real issue to try and navigate here, given the push that it has on the issue.
Right. We'd love to hear what your thoughts are on this. Reminder of the question of the week: the Western Cape High Court pausing the public impeachment hearings against President Ramaphosa pending his review application of the independent panel report. What are your thoughts on this? Give us a call, 011-714-0677-77879. I'll try to get some of your calls on air after the break. Stay with us. Welcome back. You're watching It's Topical. As you know, the show is all about having your say on our topic for the night. On our regular Word on the Street feature, we took to various streets seeking diverse insights and perspectives on tonight's topic, and this is what you had to say.
I think it's a great process. I don't think anything will come out of it. I think he will duck and dive. Same scenario as with Zuma, and he should go to court, the same like any citizen. If you break the law, whether you are innocent or guilty, right, you need to go through the process. And if he's found guilty, then he must be impeached.
I know that many people do argue that if they were in that situation, process wouldn't have been halted for them. But I also do believe that the president is not a normal civilian and shouldn't be treated as a normal civilian. I think people are innocent until proven guilty, so I do think that we should have due process.
Why do you shove so much money under the couch? I mean, why don't you disclose as a president? I mean, we are all expected to disclose everything that we do and we own. But when umongameli umphathi wayo yonke into la South Africa, you're not doing exactly that. So yes, innocent until proven guilty, but so much guilt is smelling here.
I just think we're giving him too much grace. We forgive a lot as a country that such things just go like underneath the carpet.
I still view the president as he was. The Phala Phala saga has not really changed anything. Yeah, I guess he's a trusted man. I mean, he's a businessman, and then he has been doing business with reputable people. I don't see president as a dishonest man. Everyone is innocent until proven guilty.
We do appreciate your thoughts on this. 011-714-0677-7879, the number on your screen. I'm going to take some calls in a short while. But first, Lawson, I just want to bring you in. And I wonder if there's a risk that people might conflate the interim interdict with the substantive review application.
These are two very separate processes.
Lawson, we just lost you for a bit. Just please start afresh.
Yes, I think there is a bit of confusion, Blaine, and these are two very separate processes. The review application, as we know, was launched first, and that is the substantive application that the president just brought, seeking to challenge the validity of the report of the independent panel. As we know, that matter is still going to be heard by the Western Cape High Court in the first week of September. This application that was decided on Friday was an application for an interim interdict, a temporary pause, if you like, against Parliament's impeachment proceedings, pending the outcome of that review. And that review is really, it could be referred to as the main application, because if the president is successful in that review application, it will bring a halt to the whole impeachment process. And there is a caveat to that, which we can get into later. If, on the other hand, the president loses that review challenge, then he will have to face the impeachment committee in Parliament and ask an answer to the 4 charges that are laid out in the motion of impeachment that was passed by Parliament, by the National Assembly, during 2022.
Let's go to the lines now. We understand that we have Freddie from Parys. Freddie, a very good evening to you. Is Freddie with us? All right, it seems that we've lost Freddie. I'm told we've got Lorna. Lorna from Johannesburg is calling us. Lorna, very good evening to you. What's on your mind?
What's on my mind? Well, I'm interested in the Western Cape judgment, which gave a temporary reprieve to President Ramaphosa, because he is being held accountable by Parliament, and the Western Cape judgment that's just gone through the courts puts this on temporary hold. So I've been thinking about that.
Do you have a question for our guests? Any grey areas for you?
Any grey areas? Well, yes, I wondered if the panel was interested in knowing whether President Ramaphosa has been found guilty or not guilty. How this judgment actually affects what the proceedings are at the moment.
Right. All right, thanks a lot. And it goes back to what Lawson was saying. This didn't deal with, in terms of the merits of the actual review. The Constitutional Court as well didn't deal with the actual merits of innocent or guilt. It's just with regards to the proceedings and the Rule 129I that was found wanting. Let's go to Freddie. Freddie from Paris is with us. Freddie, very good evening to you.
Good evening, Hem.
Go ahead, your question.
Very, very good evening, Hem and Blade. How are you?
I'm better than I deserve, Freddie. If you can turn down your television set, go ahead with your question, sir.
Okay, I have switched it off now. Okay. There no miscommunication between us?
I hope not. Go ahead, Freddie.
Yeah, Blaine, I want to be short now. This impeachment affairs over the first citizen of the country is just a game. You understand? The thing is that we cannot drag the senior citizen to the impeachment committee via courts or whatever. He knows all the tricks. All the judges there in wherever they are, Supreme Court, Apex Court, or wherever, those guys are being paid by him. Them, the police, all the arms of government are being paid by him. They are all loyalty, just like the IEC. I don't see anything to happen with the senior citizen there.
That's a big allegation, Freddie. Do you have any proof?
I beg your pardon?
That's a big allegation to make. Do you have any proof?
Who pays all the arms of the government? Isn't it the parliament who is being headed by the president?
I see.
Everyone.
Freddie from Paris, thank you so much. This perception, Professor Zondi, that the judges or the judiciary might be aligned to the presidency and might go back to your earlier point about the trust in certain institutions. How do you deal or explain that to Freddie?
Yes, I mean, in law, you have to work on the basis of evidence and facts, but in politics, you don't have to work on that basis. Perceptions are important, opinions are important, the feelings of people are important. Even reactions to situations on the basis of your living circumstance is a legitimate speech in politics. So that is why we're saying then that while the president can save himself from the legalities of this thing, it's hard to save himself from the court of public opinion. Yeah. The court of public opinion is that people will read every one of his actions through the political lens of any form. And given the low trust in public institutions generally, they will be skeptical of every move. Yeah. While the legal people might say it's all procedural and stuff for them, the ordinary people might see somebody who's trying to abuse the political system. Even the courts and the judges, whatever they decide, when you have a split judgment like the one we had right now, of course, there's a majority judgment. For people, it is like, no, one of them is independent, the other two are pro-president. But in their game, there's always a pro and against. You're either for or against, and that is how politics reads the situation. So what then the president is going to need is his political machinery, which is his political party, which is own personal order, to be able to engage with the public and try and put his point across. And the mistake he can make is to wait for all these legal things to finish before he engages the public. Because when he does so, the public opinion will shape itself, it will consolidate itself. The people will start to believe what they fear, will start to believe what they think, and they believe what they assume. Because remember, it is not happening in a vacuum. They've had to deal with the president of Zuma. They've had to deal with the presidency before. All of that memory is brought back to say we are seeing what we've seen before, And these people have also come back later and said, we made a mistake in the past. Will they also say they are making a mistake right now? Because people understand that these are legal processes, but there are political decisions behind them too, which is a decision to launch an impeachment is a political decision. A decision to challenge an impeachment is also a political decision. And then that arm of politics president has to cover himself, not just focus on what is argued in the court of law, but also focus on how he defends himself in the court of public opinion.
Doctor, I wonder, this judgment by the Western Cape High Court, is it more about constitutional timing and not necessarily about constitutional accountability at this stage?
I think it's both. So I think it's about timing in the sense that, remember, we have a review or we have a report that has triggered an impeachment process that is now under review. So that is where the timing part would come in. The president realizes that that impeachment process will happen because that is the role of Parliament in holding the executive accountable. So what the courts basically had to put a balance on, or what they had to balance, was the powers of each branch of government, which would then be the power of Parliament to hold the executive accountable. And then it also comes to an accountability aspect. Remember, we have that checks and balances. So basically, I think what it looks like now is that the courts have basically encroached on the powers of Parliament. I don't think that's basically what happened. What it is, it's exactly what you're saying. It's a timing issue. Because remember, if that report, if the president is successful in convincing the court that that report is, the foundation of that report is not legally sound and therefore should be set aside, it's going to lessen the legitimacy of that impeachment process. So now we're going to start looking at that impeachment process and then wondering, why did we have to go through that at all? So because also remember, the Constitutional Court didn't rule on the merits of that report. It only ruled on Rule 129I. So if the president is successful, it pokes holes into the legitimacy of the impeachment process itself, because the foundation of that process would have been basically set aside, which is that report. So I think it's both a timing issue and an accountability challenge as well. But I think from all three judgments, I don't think any of them were wrong. I think each one had a compelling argument as to why they reached the decision they did. And I think also we should remember that they did, at the end of the day, agree that this is one of those exceptional circumstances where the work of Parliament should be paused so that that review application can go through, or so that the president can basically try and convince us that the foundation of that report was flawed.
Right. Let's go back to the lines. I'm told Nhlamulo from Johannesburg is on the line. Nhlamulo, a very good evening to you. What's your question for our guest?
Good evening to you. Good evening to the viewers at home. Good evening to the guests. Well, before we get into the questions, there are a few statements that I have to, or few inputs that I have to make. Firstly, I would like to highlight or emphasize on the statement that was made by Dr. Shadi, that the High Court did not overrule the decision of the Constitutional Court. The statement that was made by Angela Mutama at the Western Cape High Court is completely false and misleading. The Constitutional Court was dealing with a different issue from what the High Court is actually dealing with. These are two different matters. It has never happened that the Constitutional Court would want to contradict with the decision of the High Court would want to contradict with the decision of the Constitutional Court. What the MKP is basically saying is completely false and it's misleading to the masses. Secondly, I myself, as a law student, I so believe that the decisions of the judiciary, or rather the Western Cape Court, is rooted in constitutionalism other than politics and political influence. So whatever decision that will be taken by the judiciary is a decision that has followed proper legal processes and is a decision that is rooted in constitutionalism. So in the meantime, while the report of the independent panel is being reviewed, the impeachment committee cannot rely on it. Because what that report actually acts like, it acts as a foundation. You cannot build a roof without a foundation. So that is that's the importance of that particular report. Right. And secondary to that, we've also addressed the issue of the case by ATM leader Zumula. Clearly, I don't think there's victory there that is going to be achieved by the ATM political party, because when you look at the dissenting judgment, or rather the dissenting judgment of the Western Cape High Court, he's stating that he believes that the decision to allow the review tends to not promote the principle of checks and balances, which is absolutely wrong. Because I don't think the decision of the Western Cape High Court goes against the principle of checks and balances. But instead, what the High Court is actually saying, they are actually saying that we think this particular report by the independent panel could pose a huge constitutional infringement right towards the president. Right. In the meantime, let us ensure that we review this particular report. Let us ensure that whatever that is in this particular report, it is constitutional, and the report is legally sound before we further continue in this particular matter.
Right.
So the parliament still can continue to hold the president accountable in terms of Section 89, but after the review.
Right. Thank you so much indeed, Nklamulo from Johannesburg. Lawson, I wonder, in terms of the broader question, and I wonder to what extent has this now become a legal tug of war over the separation of powers?
Well, it's been portrayed as that. I don't think it's a tug of war necessarily. I think the courts are playing the role that the Constitution has designed in terms of the separation of powers. That where there is a disagreement between the executive and the legislature, the courts are the final arbiters, and they will not interfere with the internal workings of either Parliament or the executive unless there are constitutional or legal issues that have been transgressed. And, so there's a very clear a way in which the courts operate in this regard. In the same way as, the argument is being made by some that the Western Cape High Court decision infringed on the separation of powers. Well, one could say the same about the judgment of the Constitutional Court in May, because there the court, intervened in Parliament and said your rules are unconstitutional. And I would point out to Freddie, your earlier caller, that was one case where, in effect, the president lost. So it's not a given that every time a case goes to court, the president wins. So, I think we've got to be clear about these things. The courts do have a role, albeit limited, when it comes to issues of directing one arm of state as against the other. And they don't do so lightly, which comes back to the issue around the actual ambit of the judgment of the Constitutional Court in May. Those that argue that this interdict interferes with that have got it totally wrong, because all that the Constitutional Court has said is that the Speaker of the National Assembly, Toko Dudisa, must refer the report of the independent panel to an impeachment committee. Parliament has discharged that responsibility. The court did not and could not tell the impeachment committee how to conduct its work, nor could it preclude the president from exercising his rights as he has done in seeking this interim interdict.
All right, let's go back to the lines. I understand we have KGM from Cape Town. KGM, a very good evening to you. What's on your mind?
Good evening, and good evening to your panel. Let me put a bit of a spanner to the discussion. I think one of the most fundamental things that we are not looking into, which also has just been maybe ignited by the Phala Phala saga with the president, is the issue of our constitution and how contradictory it is, even though lawmakers keep on wanting to impress on us to say the constitution is fair, it's balanced, and so forth. If you look at the Zuma matter, for instance, or even, I just want to focus on the presidents quickly. If you look at the Mandela issue with Louis Late, and you come to the Mbeki matter, I just forgot. I was actually reading the ruling on it, and you come to the issue of the Zuma matter, which dragged for 2 decades and all, and now with the president. If it was an ordinary member of the public who has been implicated the same way as the presidents have, Mandela, Mbeki, Zuma, and now Ramaphosa, the Constitution would not have protected the interest of the citizen, a nobody citizen, the same way that it does to the president. And here's the issue that I would like your panel to talk to. The issue of affordability of justice. If you do not have the money and the power, you are not going to be protected like the presidents are. So it's a fallacy to say we are all equal before the law. I know it's digressing a bit, but I would like your panel to really talk to that, because that is at the core of what we're seeing. The courts, the constitutional courts, the Supreme Courts of Appeal, the High Court, even the regional courts. I don't want to talk about the magistrates' courts, which are left for the lower men on the streets. But these three levels of courts are really having a problem in terms of balancing the law in as far as the people are concerned.
Right. KGM, let's leave it there. I want to get a quick response from Dr. Shadi before I go to break. Doc?
I think the challenge that we have, I don't think the challenge comes from the Constitution. We have one of the most progressive, especially when it comes to the Bill of Rights. I think the challenge we have is still in the Constitution, where it says we have limited resources. And that's where the challenge comes in, and that's where we see a challenge when we speak about access to justice. We do have access, but I think the challenge comes in when it comes to resources. So whether we are all equal before the law or not, we have the rule of law, and it applies equally to all of us. The challenge that we have as South Africa is not the Constitution or access to justice, it's the lack of resources.
All right, we need to take a quick break. When we come back, we'll tap into the better minds in terms of the way forward now. What about the evidence leader? What needs to be under consideration when evidence leaders are picked? More next. Welcome back. You're watching It's Topical. I wonder, to what extent does this judgment strain or strengthen constitutional democracy? Professor Zondi, what sort of, in the immediate short term, what sort of political consequences flow from the judgment from a political point of view?
Some of them are some of the things that are being said by the callers. One is an appearance that there is inequality before the law. The other one is an appearance that there is the courts are directing, as the legislature are directing the parliamentary arm of the state in both ways, as it was demonstrated by what Lois Knight was saying, directing the parliament to open the case, to open the impeachment process, and directing the parliament to pose the that is a real political implications for our system. And then the point that was made about the idea that there is equal access to law, to the Constitution, when actually it isn't. It is there's greater access for those who have money than those who do not have money. It's just the reality of what it is, because if it is just only in the letter that there's equal access, but not in reality, in the real life situation, then it is not. But going beyond than this particular case, politically, it does, while this is pausing the legal process, it is not pausing the political discussions. It's not pausing the political implications. I mean, think about the fact that the parliament is in this week deciding who the evidence leader is. And that evidence leader, discussion about that evidence leader will inevitably be talking about the president being impeached. The idea that the president is being impeached is a reality, though actually legally it's not happening. But politically, the impeachment is the stock and the story, and it becomes a reality in people's mind. But there's also implications for the governing coalition, because the ANC has taken a decision to say the president is right, he has his right to do this, and it can proceed it. It's his legal right to do it. And they are not saying how they're going to manage the political process that continues to happen irrespective of what the legalities are saying. The DA has said that it would not protect the president from impeachment, and I don't know what it meant, as if somebody said, are you going to protect or are you not going to protect? But they've said that, but how they're going to play it out in the next coming days. And as you saw with the ATM, the EFF, the MKP, and the other parties are full on with it. They're playing this game, and they're going to be pushing it. They're going to be talking this issue up. So this issue is going to be in our ears. It's going to go radio and TV, every media. So the impeachment politically is happening, but it is not actually happening in legal terms. Now, even if the judgment of the court in relation to the substantive matter favors the president, and the judge in Ngobo report is ruled not legally sound.
Right.
You can't rule out the possibility that there will be a vote of no confidence.
Yeah.
But the president can also be moved through a vote of no confidence. It can be moved through an impeachment and other processes. So this will continue, and it looks like once it starts, it keeps rolling unless the president has something to offer to tame the political storms and get it moving. So we're going to be talking about this matter now for another year or so going forward. It's going to hang up around his neck, whatever the outcomes of the legal processes. Because in the South African political system, the courts can talk, but people can also talk. And they are right in their own way, and the courts are right in their own way. That's a beauty of our system, that we can have all of this. So there is a tug of war, but the tug of war is not between maybe the arms of the state, but it's between the legal community, including the courts and legal analysts and all that, and the political community, which is the rest of the society, who are not bound to the confines of legal disciplines and stuff.
Right.
They can think and they can pursue their thoughts
Lawson,
the way they wish.
I wonder, in terms of safeguarding the credibility of the process in terms of the inquiry, is the impartiality of the evidence leader going to be one of the greatest tests here?
Well, that shouldn't be the question, because the very need for an evidence leader is to assist the committee in going through the evidence relevant to the 4 charges that are in the motion of impeachment, is to sift through all of that evidence and to assist the committee to ask the correct questions of witnesses, to focus on the correct issues, so that the committee can discharge the enormous responsibility that will be placed on it to make a finding as to whether or not the president is serious of a serious misconduct or a serious violation of the constitution and the law. That's what the committee has got to, the decision the committee is going to have to take, or the recommendation for the National Assembly. And the evidence leader is there to guide them through that process. So, the views of the evidence leader matter less. I mean, if the evidence leader is overtly biased either in favor of the president or against him, I'm sure he or she will be called to order by the chairperson of the committee, which is to say, you are here to help us through this, not to tell us what to do or what to think. Yeah. And so I think it's also important to say in this, whilst there are many legal challenges around this process, the ultimate decision is not one that gets taken by the courts. The ultimate decision, should the impeachment process go ahead, will be a decision of the National Assembly, and therefore, as Sipamandla says, it's an inherently political process, and you cannot easily separate the legal issues from the political ones. There is an overlap here, and I think opposition parties, and it's quite clear, some of them have set out their stall already as to how they're going to find the president. They're going to find him guilty. They haven't even heard the evidence yet, and yet some of those parties also want to start this inquiry without being paused by the interdict, because they want to impose maximum political damage on the president, particularly in this period as we run up to the local government elections. So the interdict has kind of swept the rug from under their feet there, because now this, if we only get judgment from the Western Cape High Court on the review application, say in October, political parties are going to be busy campaigning for elections. Will the parliamentary process proceed before November, even if the president were to lose the review application? I think those are some of the questions that come into play from a political point of view, and that's why some of the opposition parties are so keen to try and get this process underway as quickly as possible.
Listen, thank you very much indeed. Unfortunately, that's all the time we have, but I have no doubt these conversations will continue. Thank you so much, Professor, as well, Doctor. Appreciate your time and your expertise on this. All right, before we go, here's my take. The impeachment clock hasn't stopped. It has simply been put on hold. It's a reminder that in a constitutional democracy, justice isn't a sprint, it's a process. President Ramaphosa says he respects the independence of the judiciary, the separation of powers, and remains committed to accountability. For his supporters, it's due process taking center stage. For his critics, it's accountability waiting in the wings. Either way, this chapter isn't closed. For now, the legal ink is still drying, and the next page is yet to be written. 3 loaded words: we shall see. And that's my take. If you miss anything on this program, then be sure to watch this episode of Topical on YouTube, as well as SABC Plus. Until next week, my brothers and sisters, take care. Bye-bye. Thank you.